Okay, let's talk about secured creditors in a Chapter 7 bankruptcy. In a previous guide, I'd mentioned that with regard to secured creditors, you have three options: surrender the asset, redeem the asset, or reaffirm on the asset. So let's make it practical in terms of the application. Let's say that we have a car that we owe $10,000 on, and it's worth $6,000. If we file a Chapter 7 bankruptcy, we can either surrender the vehicle back to the creditor and discharge the debt. No legal liability going forward, but we don't have the car anymore. And it's upside down anyway. It's worth $4,000 less than what we owe on it. The second option is we can file a motion to redeem with the court. And what we have to establish with the court is the fair market value of the vehicle being $6,000, either through appraisals or through some sort of a auto trader or Craigslist advertisement, something that articulates to the judge, who isn't an expert on motor vehicles, what that vehicle's worth. The creditor's going to come in with their appraisals and with their industry NADA reports and blue books and try to establish the value of the vehicle to have it be worth more money. Because at the end of the day, in a 722 motion to redeem, the judge is going to order a dollar amount that you would have to pay for that vehicle, and it's a lump sum dollar amount usually. And so you'd be able to get that vehicle if it's worth $6,000. You could buy it for $6,000 even though you owed 10 on it still from that creditor if you could come up with that lump sum payment. The third option is you can reaffirm on the debt, and that simply means that you put yourself back on the hook for the monthly obligation. Sometimes there can be some negotiations in terms of interest rates or other terms, but really the simplest reaffirmation is we're current on the payments, we intend to remain current on the payments, and it makes sense for us to put ourselves back on the legal hook. So we're going to sign off on this, we're going to get our attorney to sign off on this, and then the creditor signs off on it and we file it with the court. A reaffirmation agreement would need to be filed with the court before the case is discharged or it's not able to be filed. I don't recommend a reaffirmation agreement on a vehicle that's upside down. So if you've got this $10,000 debt and $6,000 asset, your finances can go from bad to worse. Other things can happen. You could lose your job, and you don't want to have reaffirmed or put yourself back on the hook for the obligation on that debt, only to find out that 12, 14 months later, your entire industry or your business goes out of business and you're laid off in a reduction of force, and you can't afford to make the $350 a month vehicle payments because they're still going to repossess it. They're still going to sell it at a dealer's auction. They're still only going to get $4,000 for it. Yes, I recognize I said it was worth $6,000, but a dealer's auction, they're not going to get the fair market value that you would get for it if you sold it on the street. And so if they sell it for $4,000 and they have costs of sale of $500, they've netted $3,500 out of the $10,000. You would still owe $6,500 even though you don't have the car anymore. So you want to be very, very, very cautious about signing off on a reaffirmation agreement in a Chapter 7 bankruptcy on a motor vehicle that's upside down.